Good morning, this is your Kelso Report for Thursday, May 31st, and I'm your host, Clark Kelso. Today we have cases dealing with the Confrontation Clause, appellate jurisdiction, drug enhancements in federal sentencing, an anti-SLAPP case, and a case on settlement in an ADR context. We begin with a Ninth Circuit case involving the Confrontation Clause. The habeas petitioner in Flournoy v. Small had been convicted in a California court of one count of forcible rape and one count of assault with intent to commit rape. He alleged two constitutional violations. First, the trial court permitted a forensic analyst to testify based on the results of scientific tests that were performed and reports prepared by other analysts in violation of his Sixth Amendment confrontation right. And second, that he received ineffective assistance of trial counsel who failed to object to the analyst's testimony. The district court denied the habeas petition and the Ninth Circuit affirmed. The petitioner's problem here was that at the time of the trial, in denial of his state habeas claim, there was no clearly established federal law based on decisions of the U.S. Supreme Court that held such testimony by a forensic analyst violated the Confrontation Clause in circumstances where the testifying witness participated in and reviewed the crime lab's work, even though she did not personally conduct all of the testing herself. The Supreme Court's 2004 decision in Crawford v. Washington had clearly established that testimonial, out-of-court statements were barred under the Confrontation Clause unless the witness was unavailable and the defendant had a prior opportunity to cross-examine. But that decision did not delineate precisely what statements qualified as testimonial. It was not until 2009, after the petitioner's trial and denial of his state habeas claim, that the Supreme Court held in Melendez-Diaz v. Massachusetts that a forensic laboratory report qualified as testimonial for purposes of the Confrontation Clause. And frankly, even Melendez-Diaz held only that a lab report could not be admitted without a witness appearing in person to testify. So even today, the Supreme Court has not clearly resolved the precise evidentiary question in the case, whether an analyst who conducted some of the testing may testify as to the entire report. In any event, since the right was not clearly established, there's no availability of habeas relief under the current habeas statute. Our second case involved a capital habeas petitioner in Lewis v. Ayers, who was sentenced to death following California convictions for first-degree murder and other crimes. While seeking federal habeas relief, the petitioner requested a stay of the proceedings on the ground that he was not competent at the time to assist counsel. Following an evidentiary hearing on petitioner's competency, the district court denied the requested stay based on its determination the petitioner was competent. The petitioner appealed the denial and in the alternative sought a writ of mandamus. Well, the Ninth Circuit concluded that a district court's order denying the requested stay was not an immediately appealable order, since it did not satisfy the collateral order doctrine. In particular, the pretrial order was not conclusive as to competency, since the issue could be raised again, and the order could be adequately reviewed in a post-judgment context. For similar reasons, the court held that mandamus review was not appropriate, so the court dismissed the appeal and denied the request for a writ of mandamus. Next, we have a criminal sentencing issue involving drug enhancement. In United States v. Leal Vega, the government appealed the 30-month sentence that had been imposed on the defendant for illegal re-entry following deportation. The district court had declined to apply a 16-level enhancement pursuant to United States sentencing guidelines for the defendant's prior conviction under California Health and Safety Code section 11351. The government contended that the 16-level enhancement should have been applied because section 11351 is categorically a drug trafficking offense under the federal sentencing guidelines. Well, the Ninth Circuit rejected this argument, since the scope of controlled substances under Section 11351 is broader than the scope of controlled substances under the Federal Controlled Substances Act. Therefore, it was possible to be convicted under Section 11351 without possessing a controlled substance under the Federal Act. And given this difference in scope, it will be improper to conclude that a conviction under Section 11351 is categorically and for all purposes a drug trafficking offense under federal sentencing law. Notwithstanding that holding, the Ninth Circuit then found, under its modified categorical approach, which permits the court to examine the actual charging documents in the prior conviction, that the defendant had indeed been charged with possession and sale of tar heroin, which is a controlled substance under the Federal Act. So, the district court should have applied the 16-level enhancement, and the court remanded for resentencing. Next, we turn to our anti-SLAPP case. A bank's former employee had posted allegedly defamatory messages on the Rants and Raves section of Craigslist.org, defaming the bank and its CEO, disparaging the bank's operations, and warning depositors about the safety of their funds. When the bank sued for defamation, the former employee shot back with an anti-SLAPP motion, which the Superior Court denied. Well, the First District reversed. In concluding that the defendant's speech was protected, the court struck down on First Amendment grounds Financial Code Section 1327, which imposes criminal liability when an untrue statement or rumor is made that directly or by inference is derogatory to a bank's financial condition. The court also concluded that statements about a bank's financial condition or management are statements about an issue of public interest. Finally, the court concluded that the bank had failed to satisfy its burden of showing a probability of success on the merits of its defamation claim, because the statements on Craigslist.org were non-actionable statements of opinion. This case is, I think, a clear demonstration of just how powerful the anti-SLAPP procedure has become in protecting First Amendment rights against burdensome litigation. What we have here is a garden variety defamation claim, and it gets dismissed very early in the proceedings and without the expense of discovery and lots of pre-trial motions. A good result for the law. Finally, we have a settlement case involving arbitration. The Fourth District upheld in Bowers versus Raymond Lucia Companies the settlement of a defamation and business tort lawsuit through the mechanism of a binding mediation process. In enforcing the settlement, the court held the facts supported the conclusion that both parties had agreed to the process, that a contract term providing for binding mediation is not too uncertain to be enforceable, and that such a contract term for binding mediation is a permissible means of waiving jury trial rights. The binding mediation clause here provided that either the mediation would lead to an amicable settlement between the parties, or the mediator would then set the judgment at an amount between $100,000 and $5 million. This is known in the trade as a mediation binding baseball arbitration process. Play ball. And that's it for today's Kelso Report. Have a great day in the law.